I think I'm the last one standing between you and beer or kombucha or wine or cookies or whatever is your thing. So I will stick to time and even try to be a little faster than expected. But we do want to leave time for some Q&A, and hopefully some questions are already starting to percolate. At the outset, I failed to acknowledge that Carson has had one hand on the Rubik's Cube leading us to this point. So thanks so much, Carson, for putting together this panel and so much of today. I appreciate it. So this is focused, again, this is the law panel. This is focused on exploring new legal tools for CDR deployment. We've talked a lot about technology today and the scientific side of things, engineering side of things. This is kind of zooming out to the law and policy landscape. It's hard to know where to begin, especially because every different type of CDR technology has its own little quilt work of nascent regulatory applications and realities and hoops. We're going to just focus on a few today, primarily at the federal level. We're going to look at Bill C-5, also strategic assessment and regional assessment. Bill C-5 is a cryptic name, but how many of you have heard about Prime Minister Carney trying to push through this big bill, which Elizabeth May has called the big, beautiful bulldozer bill? That's one end of the spectrum, but many would say it's actually a nice fast-tracking process that's about to come out. This is a tongue-in-cheek alternative title. CDR, look before you leap or leap before you look. There's been an evolution in environmental law for the last few decades towards going further upstream in the decision-making and information gathering process. That's why we have things like environmental assessment and impact assessment, where you can take a comprehensive look at a whole project, look at it in relation to cumulative effects, the rights and interests of Indigenous peoples, impacts to landscapes, species, and spaces over time. That's called look before you leap. Right? Common sense. There is good reason to characterize what's happening under Bill C-5 as leap before you look, which common sense would suggest is not a great idea, but perhaps for a small number of projects, including perhaps for some of the biggest CDR, at least sequestration projects, it's not a bad idea. At lightning speed, we're going to go through this. We're going to make a comment on context, then we're going to look at C-5, and then if time permits, I'll just take you on a quick tour of what's known as strategic assessment and regional assessment, and then a couple final concluding comments. Okay, Canada's carbon management strategy. Perhaps some of you have seen this. This was released about a year ago, and this covers a lot of what was talked about today on at least the law and policy level. This is basically an inventory of federal incentives. Matthew just touched on a few of these for carbon capture and storage, carbon management, CDR, etc. How many of these tell you where and how to deploy actual projects? The answer is 0. And that's because the regulatory landscape is so nascent. Matthew did a good job, actually, of summarizing some of the nuts and bolts that are happening on sort of these subsector by subsector bases. But generally, there aren't a whole lot of rules, and there's a great need to flesh out the legal landscape, especially for things beyond CCS. So I'm going to talk about these two approaches that we see right now, Bill C-5 and strategic and regional assessment. This is just a graphic depiction of the linear process to get your project built, right? So way upstream, you have strategic and regional assessment. Then you have what's known as the early planning phase. We've heard a little bit of talk of that, and I thought AJ made some really good comments about how important that is very early on, especially in context of Indigenous rights and interests that could lead to co-ownership and Indigenous-led projects. Then we get into what I mentioned before, impact assessment, project decisions, and so on, and then regulatory decisions. A lot of what you, I think, have been thinking about when it comes to carbon dioxide removal projects is really the regulatory side of things, right? If it's BECCS, what's going on with the forestry regulations? If it's agricultural and rock weathering, it's agricultural laws and so on. But we're going to talk about going upstream. Okay, so some of you have heard about Bill C-5, right? This has been, the story is that it's being rushed through the House, right? So this was tabled on June 6th. It passed third reading exactly 2 weeks later, just this past Friday at about 5 p.m. It's with the Senate today. There are amendments percolating around and being woven in as we speak. And by Friday, it's expected that this bill will actually become law. How many, just show of hands, how many of you are familiar with this? Have you been seeing some headlines around this? Good, okay. So I actually made a last minute pivot to focus some of the presentation on this because I think there's a lot of headlines, there's a lot of political jabs and so on, but it's not really clear what this bill is actually trying to do. So here's a quick look. The basic purpose of C5, part 2 of which is called the Building Canada Act, that's the focus here, is an accelerated process that enhances regulatory certainty and investor confidence. And the kind of sales pitch around this is to shift the process from whether to how. And so it's basically just a 4-step process. Way easier said than done. But step 1, identify and list projects of national interest. Second step, all federal determinations and findings are deemed to be, quote, in favor of the project. That is an early green light, an early all-in-one green light that's never existed. This is unprecedented for projects of this magnitude in this country. Step 3, the project proponent has to satisfy all of the requirements of those authorizations. So the green light is there, the yes is there, but the substantive work to actually get those approvals still needs to happen. And finally, a unicorn pops onto the scene. This unicorn that has been described before, but never actually seen in Canadian environmental law, and that is an all-in-one federal authorization document with binding conditions. So rather than getting an authorization, as some of you may be experiencing in the CDR realm, from Transport Canada, DFO, ECCC, this is all in one document. Theoretically and legally, there must be Indigenous consultation throughout. And this picks up on AJ's point, open question in this context as to whether or not the federal government is approaching this with a view to consent being the legal standard. Is it just consultation? Might be deep consultation, meaningful consultation, but it's not clear that in all contexts consent will be the standard. We'll see. And then there are these clauses late in the bill that are what's known as Henry VIII clauses. You can Google that, but basically it gives the federal government wide-ranging powers to actually exempt specific projects from a huge swath of federal laws, including environmental laws. All of this is flowing through a new magical major projects office that takes these projects and shepherds them through the approval process to speed things up. So why leap first? Why leap before you look? Well, the geopolitical context is the big driver here, right? The elephant in the room is south of the border, and that elephant is orange. But why leap first? It gives you an early green light that provides that regulatory certainty. It's being pushed by the current geopolitical context. But also, if we put our decarbonization hats on or look through it through that lens, it's been well known for quite some time, especially after COP26, which was basically the net zero COP, that we need to move fast towards net zero by 2050. So decarbonization requires a much faster approach. And there's this criticism that things take too long otherwise. But why do we need to look first? Well, this is common sense, and this is really the wisdom that's been baked into impact assessment, environmental assessment in Canada for decades now, that there is this need to gather information so that decision-making is informed. You need to gather information to inform mitigation measures and avoid the worst potential impacts. There are good legal and beyond reasons for reconciliation, decolonization, and Indigenous self-determination, not to mention constitutional duties on the Crown under Section 35 of the Constitution Act. And also, it's important to understand trade-offs, alternatives, true costs. These are a lot of the things that Melanie and Anna were getting at in terms of public opinion this morning. And they are arguably off the table when it comes to some of these major projects that could be on the first draft of the list. So this is kind of what Bill C5 does to this process chart. It eliminates the planning phase, it eliminates potentially impact assessment, and just shifts things to these regulatory decisions. And so this is on paper what it looks like when one looks before leaps. And we talked earlier in the day about unintended consequences, alienating people, and so on. And there is certainly a major risk of this. Now, what I would say to all that, and I've said this in some of the writing I've done the last 2 weeks on it, is it's all going to come down to what projects are on the list. Right? So some projects, there is going to be good convergence, lots of common ground and tailwinds that will see projects through. But for some projects, that's not the case. The one to watch in this context is going to be the Carbon Hub, right? The Pathways Alliance Carbon Hub that's being proposed. And yes, it's CCUS, not BECCS, but that's really going to potentially clear a pathway for CDR projects of this magnitude in the future if if this approach goes forward. And that pretty much covers it on this slide. Okay, so I've got just a couple minutes. Going to talk a little bit about strategic assessment and regional assessment. How many of you have heard of strategic assessment or strategic environmental assessment? 4 people. 5, maybe 8. Okay, so this is going upstream of project-specific decision-making, recognizing that this is an emerging sector, an emerging suite of technologies. The idea is that it could be wise to go further up the decision-making chain to gather information. So there's no universal definition. It refers to a range of approaches that aim to integrate environmental, social, and economic considerations into policies, plans, and programs. It's not project-specific. So that's the idea, is that this is looking at an entire sector or proposed suite of policy measures. There is now, as of 2019, a legislated basis for this in the Federal Impact Assessment Act. I won't bore you by reading that provision. And we have a few examples of this. One is the strategic assessment on climate change that looked at how to integrate climate change considerations into project-specific impact assessment, and another, what is the eventually terminated strategic assessment on thermal coal mining. So it's not hard to imagine a strategic assessment of carbon dioxide removal. It could be triggered by the minister, or it can be requested by the public, although the minister can refuse. There's broad discretion with respect to what the scope of that assessment would be. So really, it just creates this sandbox that many players can play in. But let's go down to the last few bullets. The examples for the lines of inquiry, and this should resonate in a CDR context, is it allows for the federal government, in cooperation with provincial governments, in cooperation with Indigenous governments, and the public, to take stock of the law and policy landscape. So when you consider how fragmented and nascent the regulatory landscape is, this is a space to actually take stock and start to build coherence from a relatively early stage. It could, for example, lead to the establishment of principles and best practices for carbon dioxide removal deployment. It can also clarify some of the messy legal dimensions, like jurisdictional questions that, for example, Melanie touched on a little bit this morning. And it can also establish essential conditions for CDR, like additionality, which we just talked about, and clarifying that Indigenous consent is, or at least ought to be, the standard. With my last minute or so, I will just talk about regional assessment. This overlaps. If these were Venn circles, strategic and regional assessment can overlap, but this is landscape scale. So again, not project-specific assessment, done at landscape scale, and it can focus on one or more sectors. So if you think about what Matthew was talking about competing different land uses or competing subsurface uses, this is a way to zoom out and understand what all the players are, what all the interests are, what all the sectors are, what all the technologies are, and to build a coherent, literally, map of what could happen or what ought to happen. And I won't go into the weeds on that, but we do have a few examples that are unfolding, including some sector-specific examples. So if you look at the Beaufort Regional Environmental Assessment, that's essentially a regional assessment in the Western Arctic that looked at oil and gas. We also have a regional assessment of offshore wind in Newfoundland and Labrador. It makes total sense when you see a map like this, right? This is from Canada's Carbon Management Strategy. This is a map of potential aquifers for sequestration. As Matthew said, there are multiple potential demands on this. Why not zoom out and do a landscape scale assessment of the different interests? And to put that into perhaps even more graphic terms, this is offshore of Nova Scotia, actually. So in the upper left, you have ideal sites for offshore wind power. On the bottom right, you have ideal sites for carbon sequestration. To what extent are these mutually exclusive? We don't know. Not pictured here are fisheries. Not pictured here are conservation areas. Not pictured here are many other uses. So again, it makes total sense to do this at this stage when it comes to CDR. And I think I will wrap up things here. I will just put in one plug. So the Faculty of Law actually has a blog, kind of old school, but this is like long form legal commentary on things that are going on right now. So we have a post, for example, on C5, and I actually just put one up today on federal climate law and policy. So check it out if you need a nap. Okay, thanks, and I think everybody should come up for questions.